Honourable Trevor Mallard.
Mr Chairman, well, that was a pathetic contribution. I mean, I think it's fair to say that there's an old rule in this House. There's an old rule in this House. If you don't know anything about it, keep your mouth shut, because people will think you're a fool. But if you get up, there's a likelihood of proving it. And a member just proved that rule. Mr Chairman, well, no, she was the chair of the committee, and the complaint, even from the officials, was, I understand, that the member who was chairing the committee just didn't bother either reading or understanding the papers that were put in front of her. Not that there was that much there, not that the important people who should have given evidence were giving evidence, but the member who was meant to be guiding the arrangements through the select committee was just so slow, so hopeless, that it was just an embarrassment to the parliamentary system. Mr Speaker, Mr Chairman, I think it's fair to say that it's only in recent days that I've turned my mind to this particular piece of legislation. I haven't had any involvement with it before, and what has become clear to me is that Part 4, unusually for a bill, is where the substance and the mechanisms sit. One looks at the registration system, the requirement to register, the method of application, what's on the registration information, the purpose, the contents, and the operation and access to the register. And I want to ask the Minister a question as to access to the register. Why is it so secret? Why is all the detail on that register so secret? If we have, well, no, we're not talking. Hang on, we're not talking about the private information of individuals that the GCSB is going after. It's a question of who's registered and on what basis are they registered. Why is that a secret? No answer. No answer from the noddies opposite. Their heads all go down and they can't answer. Well, it's a genuine question. Why can we not know, as New Zealanders, who are the network operators in New Zealand? Why can't we know? What's secret? What should be secret about the fact that someone is operating a network here? What? Well, the bill is so useless that no one can explain why something which is almost, it should be pretty clear to most people who's operating a network. So why keep the fact that they're operating a network and are registered to do so a secret? No explanation. And the registrar won't even be able to tell us if Vodafone is registered or not, because that's a secret and not allowed. There's no access. Not allowed to access. It's an offence to have it accessed. It's an offence to reveal. And it's just. I mean, this frankly, Mr. Chairman, is nonsense legislation. I'm not absolute. Well, I don't want to be too critical of my colleagues who are on, and I know that Claire Curran has written a superb minority opinion on this bill, but I don't think that. I don't think that actual question. She might have missed one. Why should we try and keep the fact that Vodafone will have to, more than 4,000 customers, no doubt about it, will have to apply for registration as a network operator? Why should we keep the fact that they've gained registration as a network operator secret? One will probably be able to tell within 3 months, Mr. Speaker. One will be able to tell within 3 months whether Vodafone has got their registration or not, because if they haven't got their registration, the switch goes off. I am talking about Part 4, the changes to the register, the security clearance, the registration and the certification, all of which relate to whether or not a particular operator is able to operate or not, and the requirements, Mr. Chairman,
Honourable Trevor Mallard.
the requirements to keep it confidential. The next point, and it is, there are a number of my colleagues, I think, are going to be interested in this particular area, and that is the method of nominating employees for clearance. I sort of, in a slightly jovial way, earlier indicated that even members of Parliament in their former lives have failed clearance checks in the past, and I was, when I did that and cleaned the windows of the Defence Department as a job when I was a student, I was a window cleaner, I was accompanied by a guard who had a pistol. And pistols, and we're talking about the very early 1970s, were actually relatively unusual in New Zealand at that time, but it was there, it was open, and it was obvious. And the most secret part of those days was the economic espionage section. And as an economics student, I thought it really interesting that the two books that they had on the shelves, because they were studying Vietnam at the time and the economy of Vietnam, were Samuelson and Lipsey, which were stage 1 books. They were stage 1 economic books, were the only books that were on the shelves of the most secret part. But the point that I'm making, Mr. Chair, the point that I'm making is that people have to submit for vetting, that the operators, who certainly those who've got more than 4,000, have to nominate a person or persons who are vetted, and the GCSB go to work in a way which Grant Robertson described for the SIS. The SIS, I presume, will do the vetting on behalf of the GCSB for these particular individuals. Mr. Speaker, I'd like also now to turn to clause 75 of the bill, which is at the top of page 60. And what it says here is that a network operator must comply with a notice under section 72 or 73, despite anything to the contrary in any deed, contract, and most importantly, in any other enactment. So the question that I have is that if a court makes an order under a particular other enactment, and the director of the GCSB issues a notice, why should the director of the GCSB override the High Court of New Zealand? Why should the GCSB director, the close friend of the Prime Minister, have the right to override the High Court, or for that matter, the Supreme Court of New Zealand? It's just wrong. It is absolutely wrong and gets the law of New Zealand upside down and back to front. Because in New Zealand, what we are meant to do is to have legislation which is interpreted and ruled on by the courts, and the minister and his lackeys do not have the right to tip it over. Now, there's some, I don't go a long way back, but I remember Fitzgerald and Muldoon, because that established that principle pretty well. And that is that if you want to change the law, if you want to tip over a decision of a court, you come to the Parliament and do it. You don't have the director of the GCSB write out a bit of paper, get it ticked off by one of his mates, and override the rule of law in New Zealand by that particular process. And Mr. Speaker, it also says that if even if a compliance, that the operator must comply, even if the compliance notice involves a breach of an obligation of confidence. If that obligation of confidence is established by a court in New Zealand, then my view is that it is absolutely wrong for the director of the GCSB to make an order which overrides that court order. It is just wrong. If the GCSB doesn't like it, there are two avenues. You appeal and appeal again if necessary, and if you don't like the result at any of those three levels, then you legislate.
I move that the question be now put.
Marion Street.
Thank you very much, Mr. Chair, and I rise